Today's guest is from Canada, and I have to obviously thank Boss Lady Tio, one of my fellow client as consumer cohorts, for finding today's guest, who's Brittany Blaney. She's with Elm Law as well as Divorce Buddy, and there she is. So Brittany is one of the unicorn attorneys that understands. There she goes.
Hi.
Hi, I was like, Elm Law, Divorce Buddy, which
I think it all comes from the same phone.
yes.
So.
Oh, good. Okay. Well, thanks so much for coming. I'm saying you're Canadian, and we have lots of people in Canada, and we love having Canadian resources because today's topic, which is how lawyers can help stifle legal abuse, is clearly not just a Canadian or American issue, but it's international from what we deal with all the time. And I'm so thrilled that our friend in Canada, who we call Boss Lady, pointed me to your site, and I saw one of your famous legalese videos, which we're going to maybe replicate a little bit here. But there's a whole bunch of questions I want to ask you, and again, thank you so much for coming.
Well, thank you for having me. I'm really excited to be here. This is definitely an issue that transcends Canada or the United States. Absolutely. We're lucky here in Canada, well, I should say Ontario specifically, that, domestic violence and legal abuse is recognized by our courts now, both, physical, mental, emotional, all the different ways that we can experience this. So it's important that we have platforms where we can discuss this and both women and men can connect with people that have experienced this in the court system.
Yeah. So tell us a little bit about your background, and I love the question of what makes you so good at your job.
Well, I don't know if I'm particularly good at my job, but I definitely try to assist and empower as many people as I can through the court system. I started off at a small firm. It was just a sole practitioner, and he actually focused mainly servicing legal aid clients. And most of our clients came from domestic violence shelters or were actually refugees and had come from situations where they were suffering overseas. And then when they came to Canada, all of a sudden they were able to access the resources that they needed to kind of leave these situations that they were in with their partners. So that's how I got my start and how I sort of learned to navigate this area of the legal system. And now I'm with Elm Law, so I've moved on from there.
Yeah, I mean, again, like I love that you have a background with the types of people that we're dealing with as well, which are always domestic abuse victims and people stuck in the family court system sometimes for years. We always say that their ex's goal is to wear them down and to bleed them dry financially. And it often takes a long time for these cases to resolve. And that you say divorce is just part one, because we know there's a lot of post-separation abuse, especially through the legal system. So because these things go on for so long, I know you had said that one of the most common questions you get, which we all are terrified to ask, but what is this going to cost me? How do you answer this? Because I imagine it depends on so many factors that are out of your control.
Yeah, absolutely. I mean, I always tell somebody, the more you guys are going to fight, that's what costs money. It's the back and forth, the lawyers sending letters constantly. And of course, when you're dealing with someone who was, whether it, coercively controlling during the relationship, if they can't control you in the relationship anymore, then that is, they're going to change their tactics, right? And they're going to try to find a way that they can control you outside the relationship. And that's usually through your lawyer. If they can't access you, then they might try to increase your legal fees. That could be sending, letters every single day, bringing motions to court that really have no likelihood of success, but just, trying to wear you down or smoke you out of the proceedings per se, so that you can't afford to continue with your lawyer. So what I usually say to people when they are experiencing this type of behavior is to let the lawyer that they're interviewing with or they're consulting with know that this is what they're dealing with and see what their strategy is. My strategy is that I usually say, listen, I understand this type of legal abuse. So I will, right at the outset, maybe send a letter to the opposing party and say, you know what, I will only respond to one letter per week. You know, that's one strategy that you could take. Or just to be aware and say, you know what, I'm not going to respond to every letter. I do have to send it to you, but I won't be necessarily, you know, billing or docketing for every letter I receive, because at some point, you know, we just kind of have to set it aside and not keep responding to these things. So we just need to be aware of what's happening and come up with strategies about how we're going to not allow him to deplete the retainer, right?
Yeah, you know, I was thinking sometimes some of our clients' exes who are pro se tend to make it worse. Do you notice a difference in whether someone's represented or unrepresented in terms of going after the other party?
Absolutely. And just for Canadian viewers, pro se, I believe, is self-represented. So
Yeah.
in Ontario, we call that self-represented. So absolutely, they can. You definitely see a little bit more from a self-represented party where there will be harassing the lawyer continuously through emails. But even when they have counsel, especially if they have counsel that's just following their instructions, you know, they could be instructing their counsel to just continue to bring motion after motion in the court, and there needs to be a way in order to stop them from doing that. And there are orders that you can get, that you can bring to the attention of the court if they are bringing these sorts of motions. There are also cost consequences that you can ask for.
You know, one of the things that comes up a lot is in what you just described with our clients is like, why is that? Why is their lawyer doing this?
Mhm.
Like, why don't lawyers manage clients like our people's exes? I mean, I already can imagine the answer.
Yeah, I mean, I can't speak for other lawyers or how they manage their practice. I can say personally that I don't particularly like to bring matters to court that aren't going to win. And I will advise my clients about their likelihood of success and the risk versus the reward of bringing a certain motion. But at the end of the day, you know, if that's their prerogative, then all we can do is, you know, recognize that this is happening and continue to try to advocate for our clients and bring it to the court's attention that they need to do something to stop this sort of legal abuse from happening, right?
Yeah, yeah, definitely. Okay, so one thing that you and I had spoken about that all of our clients know about and we talk to new people about is having the need to take what we call strategic oversight of their case
Mm-hmm.
and being a really active part of the case. And that doesn't mean telling the lawyer how to do their job, but more of a collaborative approach. So how do you help empower your own clients, you know, when you have this relationship?
Absolutely. I think that's really important. You know, the way I like to handle things is that I like to work collaboratively with my clients, like you said. So, you know, from, you know, billing once a month so that they can see exactly what's happening on their file, so they can ask questions, have an open communication about that, you know, making sure that they are reviewing every single letter and every single communication that leaves the office so that they understand their file and how it's moving forward, you know, having a good conversation about the pros and cons of every step that we're taking in that case, and also explaining to them the big picture. Because a lot of the time people are just thinking about the next step, the next step, the next step, instead of thinking about the kind of global strategy of the case and saying, okay, we need to get to this point, and here are the steps that we're going to take to get there. And, you know, it might take a while and it might take some time. So let's figure out what your cost or your budget is for this. Here are the steps that I think we need to take to get there. What do you want to do on your own, and what can I do to help you? Right. And that kind of leads us into our conversation of what is a limited retainer, right? Because we can do, you know, what can you handle on your file, and then what do you need my assistance for? And then we can work together to kind of come up with a plan so that you can get through the system without being, as I said earlier, kind of smoked out by someone who might be making it really difficult to get through the process.
Yeah, I wanted to get back to what you mentioned about communication with attorneys. So one of the big things, like our clients tend to be very emotionally needy. Most of them are dealing with complex PTSD, and they will often reach out far more frequently than other clients because they're so scared and overwhelmed. So we've talked to them about establishing regular communication or knowing like my lawyer's going to make this amount of time on a regular basis, like say once every 2 weeks or something. But how do you deal with clients who are like, they need crisis driven, like I need something right now? Because we get a lot of complaints about how lawyers don't respond, and then our clients feel like they're being almost maybe inadvertently abused by their own attorney, they feel like it's the silent treatment.
Oh.
But we understand, certainly you have a lot of cases. Like, how do you deal with clients who are still dealing with the trauma? And we know already how traumatizing it is just to go through the court process as well.
Right. Well, when somebody comes into the office and they want to retain me as a lawyer and they've been through some sort of PTSD or trauma, the first thing that we recognize is that, we need to have multiple meetings in order to ascertain what their position is. And I usually like to get them to write that down so that I know, exactly what we're dealing with and how we're going to structure, the services they need. One of the things I always like to say is that your lawyer is not your counselor or your therapist either. We're too expensive to be your counselor or your therapist. So anyone who's going through this process needs to have not only a safety plan, but also kind of a circle of support. So I always say, find a counselor, surround yourself with family and friends, because you need to be able to rely on somebody other than your lawyer. It's going to be a problem for you if we are your emotional sounding board. We are here for legal advice. We can, and as much as we may develop a close relationship, it's too expensive for you to be relying on us in that way. So, also having reasonable expectations for your lawyer, also at the outset, setting out the lawyer. Me, for example, I'll usually set out a level of expectation with correspondence. I'll say you need to have an email address. I cannot be calling you or taking your phone calls every single day, but I can guarantee you that I will respond to your email, within 48 to 72 hours. And I usually say that because sometimes I'm in court and I simply can't access something. We also need to kind of have an understanding, and usually this develops over time, about what's deemed urgent, because a lot of the times what will happen is I will get those emails. This is so urgent. This is so urgent. She needs to leave court. And I will do that. And then it's not urgent. And then unfortunately we have this chicken, this calling wolf situation where, well, is something actually urgent or is it not? And that just kind of takes time and getting to know your lawyer and figuring out, how your case is going to be managed, right?
Yeah. Yeah. Something you just mentioned about having clients write down what's going on. I think that's so helpful because, first of all, that's something they can do on their own time. You don't have to sit and watch them do it. And secondly, as someone who's journaled herself since I was 13, it's so helpful to get it out of my head and on paper. And, when you write, a lot of times things come out that are very clarifying that you never imagined. So I love that you have people do that.
Yes, well, we know that anyone who's experienced PTSD or trauma in their life will have a hard time sometimes recollecting things. So, I explained to a lot of the junior lawyers with us that, you can't get frustrated with clients because sometimes they'll say one thing to you and then the story will change in the next meeting. It's the same way as when you're interviewing children. You need to interview 3 or 4 times in order to really flush out what the accurate information is. And it is very important that you get that accurate information, because you're writing affidavits in court. You're swearing that information to be true. And we know that trauma can affect memories. So I think absolutely, I always tell them, sit down in the evening when the children are asleep and write out your story, dates, times. And also, I'm sure you recommend this to clients, keeping journals throughout the course of the relationship or the post-separation relationship, dates, times, incidents, keeping very clear notes of all of these things, because that's what's going to make you look most credible in court, having clear explanations, stories, dates, timelines. That's what creates credibility, right?
Yeah, and I mean, we always focus on establishing someone's patterns of behavior over time. And I know just from journaling, without even imagining that I would be in court for 9 years, like while I was still in the relationship, when I look back and read those journals, it's, a lot of times you write when you're tired. And so things come out, your subconscious comes out and it's like, how could I have not seen this sooner? So it's really good to have those detailed things. I know my own divorce attorney, who's a wonderful person, was saying, let's use these journals. Like, there's so much you have here that we can use. We didn't end up using much of it, but it was helpful for me to just remember what I had already written in the past. So yeah, that is really great. I mean, unfortunately, they're meeting you possibly at the beginning of the divorce, so I don't know how much time there would be, but still, I think keeping recordings of anything in writing is good, if not for court, but just for yourself.
Absolutely. absolutely. Yes. And it's therapeutic to write things down, right? So
Yeah, for sure. Okay, so a little while ago you mentioned limited scope, and we talked about this a long time ago, but could you talk about what limited scope or unbundled services is and what Divorce Buddy is?
sure, absolutely. So we talked a little bit about kind of being empowered in your litigation process, and I think that's really important for me for any of my clients is that they should feel empowered when they enter court, not silenced or victimized again. They want to understand what's going on, feel in control, because it can be extremely frightening and both financially and emotionally. So when we talk about something being financially frightening, obviously everyone has a budget about what they can handle. And some people can't afford to hire a lawyer full scope and have them just take over and manage the file. So with my firm in particular, we've created a kind of separate entity that works within our firm called Divorce Buddy that will structure, you can basically, it's almost like picking and choosing the sort of assistance that you need in respect of your legal services. So whether you want assistance preparing documents, whether you want just some coaching to go to court, or whether you want someone just to come and speak for you at court, you can kind of pick and choose the services that you need that best suit how you're going to move forward. You could just work with us at the beginning. I know this happened with you. You kind of have a lawyer assist you at the beginning, and then you feel, you know what, I think I can take it from here. So, it's just a way for us to help the self-represented litigants kind of move forward through this process. And we do know that I think 80% of litigants in court right now are self-represented. And unfortunately, we also know that they are more likely to lose at motions and case conferences purely because they don't understand the system or how they are supposed to submit evidence, and that's a shame because they could be very well articulated and they could be able to present their case very well, but unfortunately, they didn't hit timelines, or they hit the wrong page numbers, or they didn't understand how they were supposed to file something in court. And it's a shame to lose on those issues, right?
Yeah, absolutely. We always tell our clients, like, use a lawyer to help you, if nothing else, just with the procedural stuff, because where we are with appellate briefs, there's like a very specific margin size. If you deviate from the margins, you're done.
Oh yeah, it's very testy. Even as lawyers, we're getting stuff rejected from court all the time for the tiniest little procedural issue, and it's so frustrating. But access to justice, especially after the pandemic, is a serious issue. It's hard to get into court. There's limited court dates in my area anyways. So anytime that you do get in front of the court, you don't want to squander it because you didn't file your material properly, right? You want to have your evidence in front of the court.
Right. We always talk about you don't want to waste the court's valuable time because and we often compare it to like a Super Bowl commercial where you have 30 seconds and you spend $1 million to get that spot, and you need to make sure you're really on and talking about what you need to talk about instead of wasting it.
Yeah, and it's also about knowing what information the court wants, right? A lot of the time you go there with all of this unnecessary information, and although it seems important to you, it might not be related to the relief that you're specifically seeking. And then what happens is you just end up frustrating the judge, and you don't want to do that. You don't want the judge to be frustrated with you. So, working with a lawyer, at least to kind of isolate the information that you need to have in front of the court so that you can get the result that you're looking for.
Yeah, I mean, you and I are both on TikTok, and I don't know if you've ever seen people making videos. They're like, I have all this documentation for court. I am ready. And they start panning across. You see binder after binder. And I'm thinking, oh, this person's going to fail because this is too much. Nobody has time. We often work with our clients as well on what we call targeted documentation. Exactly what you said, the stuff that matters in this particular motion on this particular date.
Yeah, absolutely.
Because people want the judge to hear everything, and it's just never going to happen.
Yeah, I know. It is unfortunate. People want their day in court, but there is a strategy as to how you're going to really win your motions or win your trials or whatever part of your proceeding that you're at.
Yeah. Okay, so one thing that I know starts at the beginning of the end for many people is their spouse will say, "We don't need a lawyer. I'll handle it." And from then on, they start giving their exes, like our clients, legal advice. And you said one thing you say is you never take legal advice from your ex. So tell us why not.
Well, I actually consider that part and parcel with legal abuse. So I'll be on the phone with my client. We'll talk through an issue. We'll have a strategy, about how we're going to move forward on a particular issue. And, he or she will feel confident in that position. Then they'll go off and they'll speak to their ex-spouse, and that ex-spouse will say, well, I have a lawyer from here and I have 3 lawyers and they say that this is the law and you're going to lose this and you have absolutely no hope, so you should just take this deal and da 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 da.
Yep.
etc. And then what do? They come back to me freaking out, and then we have an hour-long conversation. So what just happened? My client just had to spend double the price on the same issue, to which I say, let's not take legal advice from our ex-spouse, okay? Once I've explained something to you, try to avoid if you have a lawyer, there's no need for you to have discussions with your ex-spouse if you can't communicate. If you guys are amicable and you want to work out a solution on your own and then bring it to the lawyers, of course, that's fine. But if you know that you do not communicate well and that person is manipulative or whatever they might be, then there's no reason for you to be having side conversations with them if it's going to only increase your legal fees at the end of the day, right?
Yeah. And also, we often tell our clients, your lawyer is your ally and advocate. And now it's almost like you say, it's your ally and advocate. That's your person. They're in your corner. Your ex is not in your corner, or you wouldn't be dealing with this.
Yeah, absolutely. So it is definitely another form of legal abuse, right? Because they know that you're going to run back to your lawyer and ask a ton of questions, and you're going to get charged for that, unfortunately.
Right. And there's a guy that I've interviewed a few times named Steve the Bodyguard, and he has this quote that I love, that an abuser's greatest tool is fear. And so that's what happens with these conversations. Someone talks to their lawyer, then they go talk to their ex, and their ex scares them. Yeah. So that's part of the whole process with legal abuse as well, is always being terrified, feeling like it's never enough. I need to get more advice. I need to get more information. I need to hire another professional, do the same thing that I've already been doing.
Yeah, definitely. It's, there's lots of ways that controlling behavior can continue post-separation. And it's just a matter of recognizing it. And then once again, coming up with a support circle so that you can recognize those things from happening and avoid them. Because a lot of the time we don't even realize that controlling behavior is happening, right? Until a third party points it out to us.
Well, I mean, how often, I think for myself, like in a relationship for 20 years, didn't know that abuse was anything other than physical, and so thought, oh, well, this doesn't really count. And then we always talk about the light bulb moment after. Like often people don't even know they're in these terrible situations because it's become so normalized.
I know, and we're so lucky in Ontario and Canada, I believe, that the courts are now recognizing that emotional and mental abuse is just as damaging as physical violence can be on families in a whole, right? So.
That's great. I often talk about how progressive Canada is, and then the Canadians jump in and say, no, it's not.
Okay. It's still new, so it's still kind of moving through our court system. But it has been there have been changes to the legislation, and we also have Kira's law that requires new judges to have training in understanding domestic violence victims and how it can affect the family structure. So we are moving in a positive direction in that respect.
That is great. Okay, another thing which I had put in my notes and I forgot what it is. What's adverse influence?
I think you mean adverse inference. Adverse
inference. Okay.
An adverse inference is just basically a conclusion that the court can draw from someone not responding to something. So, for example, if someone refuses to provide certain financial disclosure, then they can draw an inference about income, or it's just a term used when we're in trial or at motions, and an adverse inference can be drawn from their silence on an issue.
Okay, so that's something that people need to pay attention to.
Oh, absolutely. So, I mean, if somebody makes certain allegations against you in an affidavit, then you're going to want to respond to those allegations, even to say, that this is untrue and I hold them to the strictest proof thereof. Just you want to be able to respond to everything that somebody brings up.
Okay, so speaking of the way to respond properly, you speak legalese, and that's how I found you.
Yeah, I tried.
And so you have some very famous translations. And so I was gonna, while I have you here, I actually have two things I want you to translate. One is the one that you've done that I think got a lot of notice. So how would you translate, Your Honor, this man is a crybaby and a liar, into legalese?
Yeah, so these are really fun, right? We just have on our TikTok, people will comment on the videos and ask us to kind of take some sort of situation that they're going through and put it into a legalese translation. Sometimes the things I say are just in fun, and sometimes they are actually the way I would probably respond in court. So with this one, it was more fun, but I said, how I would call a man a crybaby and a liar is I would say, Your Honor, this man has proven himself to be not credible. His testimony is as false as it is fractious. In fact, his argument would be better served in a sandbox.
That's great. Okay, here's one I'm just going to throw at you because this is one of the most common things. How would you say the other side's lawyer is just throwing out false allegations?
I would say that, Your Honor, well, first of all, the lawyer can't really be throwing out false allegations. It would have to be the client's allegations. But I would say, Your Honor, there is no evidentiary basis to support what my friend is purporting, and I hold them to the strictest proof thereof.
Very, very good. All right, I'm sure people are taking notes on that specifically. All right, another thing that we talk about is vexatious litigation, which kind of fits in with legal abuse. We also call it stalking through the court, judicial terrorism. But you've had experience with, specifically with vexatious litigation, you've had success. So can you tell us what it is and what happened?
Yes, absolutely. Now this kind of will be in the context of Ontario, because obviously I'm only licensed in Ontario. So this does not translate to other provinces or to any states. But vexatious litigation, so a vexatious litigant award is actually a civil remedy. So it's not a remedy in family court. And what that would do is bar an individual from bringing any action in any court against any individual. So this is basically barring someone's access to justice, which is a very difficult order to ascertain. But what people don't understand, and what I have actually been successful in, is getting a more limited order. And it is not necessarily a vexatious litigant, but what it does is under Rule 1.8 in the family law rules, if someone hasn't followed orders to pay costs, so you've been to trial with them and they haven't paid their costs, or they haven't followed their orders for child support, and yet they still keep bringing actions against you, we can have them basically prevented from bringing any further action against you or the individual in any court in the superior in any superior court of justice. So it's sort of a muted version of vexation court, but it's against one individually. So thing to consider if that's what you're experiencing in family court. But once again, you're going to have a final order that they're not following.
Uh-oh, Brittany, you're cracking up or crackling up. I don't know if you can hear me. That just the last like 5 seconds. Can you hear me?
Yeah, I can hear you.
Okay. All right. So the last, because yeah, the screen is like a little pixelated. So with the vexatious litigation, is that the same as like a frivolous litigation? I know you said you got this limited thing where someone who has an issue where they haven't paid costs or they haven't paid child support, and they're still filing motion after motion against you or the client that they can't do it anymore. But is
yes.
Go ahead.
Sorry, you're breaking up too. So I was just.
Oh no. Oh no. This was going so well.
It's important to note that this is not an order that somebody is a vexatious litigant. And if you use that language, you won't be successful. This is purely, this is purely requesting that someone not be able to bring a further action against you until they've complied with another order. So in essence, it's like having someone deemed a vexatious litigant, but you cannot use that language. And once they have come into compliance with the order, then they will be able to bring more action against you. But in some of these cases, as you know, when you have 9 years of litigation, the cost orders can be exceptionally high and difficult to pay off, right?
Yeah. So, okay. All right. Yeah. I mean, that's because part of what we always think about is legal abuse is somebody else filing motion after motion after motion just to keep you stuck in court because you have to respond. So you either have to pay a lawyer, so you have money coming out of pocket. And if you're pro se, then it's time taken away from work, your life, parenting, the emotional cost, lack of sleep, everything else. So it's a big deal. And we know something called legal abuse syndrome is how the body is so affected as well from all of this trauma caused by staying stuck in the court system.
Absolutely. And that's why it's so important that you do create that circle of support, and there's so many great resources out there to assist you. I know in my area, there are organizations that offer court support workers on top of counselors that will assist you have the children in post-separation counseling. There's so many great resources out there if you kind of go looking for them so that you can create that circle of support when you're entering into this kind of minefield that is litigation, because you really do need a team. It's one of those things where you need a village again, because it is going to be, regardless of if you get the right lawyer, it's still going to be difficult, right? I know that. It's not going to be an enjoyable experience. So it's just a matter of, creating your best chance, right?
Yeah, I mean, as you're talking, we have this weekly legal abuse support group, and we have clients from all over the world, but we meet on Sundays. But one of the things we do is share resources. And it's not just Chris and I sharing our resources. Our clients have gotten so well educated that they share their own resources, and I just love it. Like, we learn so much from our clients too, because they're really good at finding information, especially free resources.
Absolutely. That's fantastic. Well, thank you for having this platform to assist people, because it's so important.
Yeah. Well, speaking of assisting people, so earlier you talked about how to help your clients save money and time and energy, but you also help your clients feel empowered. And we know that people often coming out of these coercively controlled relationships have given their authority to another person, and sometimes make the mistake of taking that same mentality into the lawyer relationship, where they're like, oh, good, now I have this knight in shining armor who's going to save my life, and I'm going to give them a bunch of money and they're going to take care of it for me. And we don't want that to happen. We think it's an opportunity to sort of pull yourself together, because you're going to have to go on with your life without the lawyer. So what do you do to help your clients start that process?
Absolutely. Well, the first thing, like I said, is, advising them that they need that support system. They need the counseling. They need the legal support worker. They need to kind of figure out what their next steps are and come up with a plan, right? And then we set out the plan. Sorry. And I explained to them what our strategy is. They're completely involved in that strategy, and they have to be involved in every single thing that happens moving forward. So, we're not just going to take over the case from them. This is their life, and they need to be an advocate in their life, and I will be an advocate for them as well, right? So being available for your lawyer. Sorry, I'm getting a tickle in my throat.
That's okay.
And that's what's going to help you come out of this on the other side, right? And also will help you feel stronger when you know what's happening and you understand each step of the process.
Right. I mean, having that clarity, I think, is what helps people calm down. Like, one of the things we work with our clients on is presentation. We say the goal is to be calm, and the way to be calm is when you're focused and organized. The only way you can be that way is if you understand what's going on, and you can plan appropriately, and then be ready for whatever happens.
Yeah, sorry, I've been a little bit sick, and I've been okay up until this point, but it's kind of
That's okay. That's okay. I'm checking the time, and we've been talking for a while. So, just lastly, how can people find you? I know you're just, Ontario, but how
Yes.
can people find you?
So we're on TikTok. We do on Elm Law on TikTok. We also have Elm Law on Instagram, as well as Divorce Buddy, where we are giving out weekly kind of family law tips as well as estate litigation tips. And we are available to anybody looking for legal advice in Ontario.
Okay, great. Well, thank you so much, Brittany. I know you've had a busy day too, so I really appreciate you taking the time out to do this.
Thank you so much. Thanks for having me. Have a great
Okay,
day.
you too. Bye.